Hi there and welcome to this DPO briefing. This is targeted at English NHS particularly, but obviously can be used in other areas. The law discussed in here is all English and mostly related to healthcare, but does cover some other areas too. So welcome. We have this jumble of letters here which everyone gets really confused about. So what I'm going to go through is explain what these letters all mean and hopefully make things a bit easier for you. So first of all, don't panic. Okay, we're going to go through these. It'll take a bit more than 5 minutes, but a couple of minutes. Don't forget, if you're a customer, you can email me or call me at any time for details of any assistance you need on these things. You don't have to suffer in silence. So what do they all stand for? Well, Access to Health Records Act, Access to Medical Records Act. These are two older acts that predate the UK GDPR and still have some applicability in some special areas. The Data Protection Act and the UK GDPR both basically came in post-Brexit. Data Protection Act 2018, which brought in the GDPR, but then post-Brexit we got the UK GDPR. These are the laws that now apply to personal data processing in the UK, and if you want to know more about personal data processing, have a look at one of the other videos. Freedom of Information Act came in 2000 and basically applies to information about the public sector. I'll talk about that in more detail in a moment. And DSAR, or just SAR, is a subject access request. That's one of the rights under the UK GDPR, and people often exercise it and quite often abbreviate it to that, which is why it's in the letter salad. So basically, all of these things apply to different kinds of data, but the ones with green arrows apply to data about the data subject or patient, whereas the Freedom of Information Act actually applies to only data about the organisation. It doesn't apply to patient data. This is a little bit of a problem. Because it doesn't apply to patient data, we will often receive things saying, under the Freedom of Information Act, I require you to provide something about the person. We can't do that. We have to formally reject it, and then we have to tell them that we're going to treat it as a data subject access request under Article 15 UK GDPR. The reason we have to do that is because the ICO is quite strict about this. If we do not answer the Freedom of Information Act request, that is a breach. So we have to make sure that we answer it, even if we're saying, no, you've asked under the wrong act. FOI only applies to organisational information, and it's intended to allow scrutiny of the public sector. That's the whole point of it. Make sure public money is being spent wisely. Doesn't mean we can ever ask what the purpose is of a request. We can't generally take that into consideration. We've got 20 working days to provide it, and there's another very similar regulation that covers environmental information. So here's two examples of how you might get asked for an FOI as a GP, say. Okay, these things are fairly common. Both of those are valid FOIs and would have to be answered within the timescale. I mentioned EIR just to compare FOI and EIR. They've both got similar timescales. They both exclude personal data. Obviously, FOI excludes environmental information, and environmental information regulations include environmental information, exclude everything else. Okay, there's a number of exemptions under them. You can't extend FOI, but you can extend EIR for a number of reasons. You can charge a fee under FOI. There's no fee under EIR. If you're a school, by the way, it's the working days is school days only, which is quite nice. And any clarification or fee notice posted to the clerk for freedom of information, and of course similarly for EIR. So that's a quick summary of those. Moving on to the Access to Health Records Act. This is slightly different across different parts of the UK. So in England, Wales and Northern Ireland, it applies only to records for the deceased. In Scotland, it also applies to records for people that do not have capacity. We can only supply data to either the patient's personal representative, that generally means the executor, or a person with a claim on the estate. That could be anyone, but it's commonly relatives, that sort of thing. Strictly, we should only supply data relating to the estate under this law, but we can supply additional data if we wish. So, for example, a daughter asking about whether her father died of a hereditary illness, obviously we'd be reasonable in answering that question. We should always respect the deceased wishes and their right to privacy. So if the deceased said in life, I don't want my data shared with this person, we have to respect that, even if they might have a right to it otherwise. Okay, this is all done to what's called common law, and I'm not going to explain that in this, but just be aware of that. Please consult if you're not sure on this one. The Access to Medical Records Act is somewhat different. It applies only to reports for employment or insurance purposes requested under the Medical Records Act. The employer or insurer must tell the patient they're going to ask the GP for data. The patient can refuse to allow the request. Even if they allow the request, they've got a right to see the report before it's given to the employer or insurer, and they can also correct the report. Obviously, that's within limits. We wouldn't falsify our report, but if there's information we've put on there the patient disagrees with, we would put that into the report. 21 days after we provide the report, whether the patient has responded or not, we provide it to the requester. If the patient has said they do not want it provided, we do not provide it. And the patient can request a copy as well. So that's fairly straightforward. Don't tend to see many of those these days because people tend to cheat a lot, and cheat's probably a bit too strong a word, but they tend to use the subject access request right to get these things instead of getting someone to write a medical report. Okay, Data Protection Act, the UK GDPR, and subject access requests. So these are all linked. Data Protection Act is the main law in the UK. The UK GDPR, it was brought in as part of the Data Protection Act, and the data subject access right is one of the articles in the UK GDPR under the rights of data subjects in articles 13 to 22. So Article 15 gives you a right to have access to your data. We've got to supply a copy of the data free once. Okay, and after that we can sometimes charge, but charging is never simple. No matter how big the record is, we would generally have to supply it, although we can say, look, this is a really huge record, can you tidy it up a bit? Sometimes people will ask under the Data Protection Act, that's absolutely fine. Sometimes they don't quote any act, that's absolutely fine, because it's a right and they don't actually need to quote anything. If they ask under FOI, as I pointed out, it's a bit harder because we have to actually respond to the FOI request and say, no, you can't have it under FOI. So here's a little knowledge check for you. So here's a list of a letter that was received by a particular public sector organisation. In this case, it's probably a council, and it's probably Enfield Council because I've made it in Baker Street, Enfield, but hey, it doesn't really matter. Okay, so you can see the person's asking for a number of things here. Now, those things are not all under the same law, even though they've asked under FOI and they've said within 28 days. It's not 28 days, it's 20 working days, but that's fine. So if you look at them, if we go down the list, okay, here's which laws actually apply. So because the person is asking for their council tax payment record and housing benefit records, that's their personal data, that's DPA. Also corresponds between themselves and the council, that's DPA. But minutes of internal meetings relating to the property, that wouldn't be their personal data, that would be under FOI because it relates to the property. Okay, and we don't actually know if they own the property or not, to be honest, because it's not given here. Any internal correspondence, I said, relating to property, okay, that would also be FOI. Correspondence between the council and my landlord. Right, so we do know they don't own it. Any correspondence between the council and my landlord relating to the property? Well, that might be under FOI, but it might be confidential to the landlord, so we may not be able to supply that one. That needs a very careful looking at, which is why I marked it in red there. Any environmental noise complaint records in the immediate area, including correspondence, that would be the environmental information regulations, and any other nuisance complaints would probably be environmental information regulations as well. Nuisance tend to be covered under those. Okay, so bear in mind that a single request may come in multiple parts and maybe have to dealt with under different laws, and we have to be clear which one we're dealing with them under. And if they've done like this, where they've said under FOI, or if they said under EIR, we would have to formally reject them to say, no, 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 we're going to deal with this under that law, we're going to deal with that law. Okay, so bear in mind, I'm here for you as your DPO. That's what you pay my company for. If you're already a customer, feel free to call or email. That's what we're here for. We only charge a flat fee per year. There's no usage charges. And for many of our healthcare customers, in fact, we are paid for by their ICBs. So therefore, they don't actually see a charge themselves directly. If you're not a customer, feel free to email our sales department and ask if you'd like to become one. Okay, we do offer these services widely across the public sector where DPOs are most required, but also to private sector organisations if they require it. So thanks very much for listening. I hope it was useful.